stand for these values. Now, Mr. Speaker, to turn specifically to the anti-crime bills, the 6 bills could be divided into three groups seeking to achieve 3 different objectives. The first objective is mandatory minimum sentencing, and this involves the amendments to the Firearms Act, the Offences Against the Person Act, and the Parole Act. The intention, Mr. Speaker, as I understand it, is to send a clear signal of the serious nature of these offenses and the consequences of being convicted for committing these offenses. This is quite understandable. Only, I believe it was last year, Mr. Speaker, we had a case of a reputed gang leader from the Cockburn Pen gang. How you pronounce it? Cockburn Pen or Cockburn Pen? This person was this gang rather, was allegedly responsible for 60 murders, or over 60 murders. The man was arrested and charged for illegal possession of 2 what turned out to be stolen firearms. He pleaded guilty and ended up with a suspended sentence. Many persons, not just in the public, but persons, officers in the police force, were perplexed at the seeming slap on the wrist treatment of this dangerous criminal. So we can understand why the thrust for minimum sentencing. On the other hand, criticism of these bills has been centered on the removal of judicial discretion, the fact that they dictate the same minimum sentences for a broad range of offenses, and that they generally restrict judges' freedom to evaluate cases on their own individual merit. Another criticism was that it blurs the line separating the responsibilities of the legislature from those of the judiciary. And, Mr. Speaker, earlier this afternoon, I raised another important consideration when we were dealing with the plea bargaining regulations, and that is how the passage of these bills will affect the operation of plea bargaining. In instances in which a person suspected of being affiliated with a criminal organization, or in which a person is considered able to assist in obtaining evidence against such an organization, a minimum 15-year sentence reduces the room that law enforcement would have to negotiate the cooperation of witnesses. In fact, we were recently introduced, or the term cooperating witness was recently introduced into the popular lexicon. We're asking the government to consider whether the same objective of these bills could not be achieved through sentencing guidelines, where the judge would be administratively obliged to observe the guidelines, or alternatively state that in a particular case they deviated from the sentencing guidelines because it would be manifestly unjust, oppressive, or inappropriate to do so. Mr. Speaker, if I believe these sentencing guidelines are a more appropriate and a more elegant way to address this problem, but if they're not acceptable to the government, then perhaps they could look at having some higher court or tribunal be able to review those cases where, again, it would be manifestly unjust, oppressive, or inappropriate to apply the mandatory minimums. Mr. Speaker, I want to now turn to the bill involving the extension of the powers of arrest and detention under the Constabulary Force Act. Again, the concerns that we had in the Joint Select Committee, concerns raised by various interest groups, is that the amendments run counter to the principle of the presumption of innocence. Perhaps equally important, it encourages net fishing for criminals rather than spear fishing. Rather than going precisely targeted to the persons of interest, you sweep up a whole heap of young men on the corner and you take them in for processing. That is the approach of the Suppression of Crime Act. That is an approach that has shown that it has failed historically. Mr. Speaker, we can understand how in certain specified situations this might be helpful to the police force. And some people say that in any event, it only marginally extends the existing powers under the Constabulary Force Act, and that there's a sunset provision, which means it would expire after a year, if not extended by Parliament. But as we have seen in the past, once these measures are put on the books, they tend to be routinely extended. Mr. Speaker, I want to now turn to the two bills that involve restrictions on the granting of bail. In many ways, these are the ones that will be most subject to abuse, because here is where you could restrict someone's freedom for 60 days solely on the basis of allegations. Solely on the basis of allegations. Because that's the basis on which a person is charged. That's the basis on which a person is charged. There is no conviction. It's not like mandatory sentencing, where at least you'd have had a conviction. This is on the basis of allegations. A few weeks ago, Mr. Speaker, we had a debate on the Independent Commission of Investigations Act. The Prime Minister catalogued the history of abuses by members, errant members of the security forces. With that fresh in our mind, do we want to give such powers to the same police force, who, albeit we're trying to clean it up, but we know that there's a way to go? Do we want to give these powers, which are so easily abused, which are subject to all kinds of sort of personal prejudices? I believe this is very dangerous, Mr. Speaker. The amendments run counter to long-established principles of presumption of innocence, habeas corpus. It too encourages this net fishing versus spear fishing approach. It reduces judicial discretion, and it places the burden of proof on the detainee to establish the need for being granted bail. Now, there are two bills here, Mr. Speaker. One, again, has a sunset provision, but the other makes permanent changes to our approach to granting bail to accused persons. I think that we really have to be very careful. Some amendments have been made, or some adjustments to the original bill, which involve, for certain specified offenses, persons not having a right to bail for 60 days. But what the effect of those amendments, and I know we'll go into the details of the amendments in committee, but the effect of those amendments, all it says that the persons can be brought before the court within 7 days and at 14-day intervals to determine if they've been properly charged. So to see if their offenses fall within the schedule, or if they are, in the case where they are a second offender, if it is indeed correct that they are a second offender. But it doesn't deal with cases where their continued detention would be unjust or inappropriate.